What's up, Legal Research and Writing 2? Prof. Murphy, and I'm back here today at the Suffolk County Court Complex. So today we're going to be talking about the purpose and format of a legal memo. And your instinct, your thought might be, well, a memo, of course, a legal memo especially, is one that goes to the court. Not the case at all. So today, sit back and let's learn all about what a memo does for us in our law office. The legal memo. We keep talking about it in my class. You probably have talked about it for quite a great deal in Croft's class or Singh's class or even Noe's class if you had one of those three faculty for Legal Research and Writing 1 or Introduction to Legal Studies. I've mentioned it in the face-to-faces, particularly for Module 3, when we started sort of synthesizing our rules together for New York General Obligations Law, Section 11101. At the end of the day, what is it? The legal memo, to start, is an internal document. What do I mean by that? Well, a lawyer does a lot of writing. It's a big part of the job, no matter what type of law you practice. Whether you're doing criminal law, civil law, federal court, state court, family law, commercial law, real estate law, personal injury law, it really doesn't matter. Writing is a major requirement of the job, and you write all sorts of things. You write motions for the court. If you're appealing a case, you're going to write briefs, appellate briefs, different than a case brief that you'd write when doing your legal research. You'll write those for the court. Either a motion or a appellate brief are what we call persuasive legal writing. Persuasive legal writing means who's the intended recipient. The intended recipient is the court. And with a motion or with a appellate brief, what we're trying to do is convince the court that our argument is the correct one, not our adversaries. It's ours. Judge, listen up. You need to rule for our client, and here's why. Other writing you might do in your work as an attorney down the road is doing what we call letters. All right? Some of you also may have worked on these in the lower level introductory legal studies classes. Occasionally, to communicate with the adversary, meaning the attorney for the other side in a case, it's one thing to talk on the phone, but there's really no record of the phone. Could you record the conversation? Someone might ask that. Yeah, sure you could, but it's not a real good professional courtesy to do so. And myself as an attorney, if my adversary asked, do you mind if I record this conversation? I would say absolutely. Absolutely. Why? We're talking about potentially confidential information regarding our clients, regarding a settlement, regarding negotiations. That's not something you want a recording of if you can avoid it. So occasionally you need something on the record. And again, for the reasons I just discussed, asking that attorney, that adversary on the other side, hey, can I record this, is probably not going to fly. So what do? We send letters. And of course, when that letter is going to an adversary, not to our client, it's also going to take on a persuasive form. It's also going to be meant to present our client's arguments, our client's evidence, our client's position in a way that appears to be successful, in a way that appears to be the winning strategy. We're never going to compromise or give in when we're writing a letter to an adversary. So more persuasive writing. Then there's this third kind of legal writing, and that is inter-office, meaning in our office. It's not going to somebody outside of the office. It's staying right inside our office. And when we're staying right inside our office, what do we have the benefit of doing? Well, we don't need to cage our writing persuasively. We don't need to cage our writing in terms of not giving away any of our clients' weak points or drawing attention to something that might be a little more challenging for our client as we progress through the litigation. When it's internal, a judge isn't going to see it. A law clerk's not going to see it. The adversary certainly not going to see it. We are not allowed, in other words, to write objectively. We could be honest in our legal writing when it's internal. We could be honest in our legal writing when it's internal. And that term honesty is reflected as objectiveness. That's what we call it, objective legal writing. Now, where persuasive legal writing is trying to win, objective legal writing is not. Objective legal writing is instead trying to give us an entire 360-degree picture of our client's case and our client's legal issues. Whereas persuasive legal writing is very one-sided, objective legal writing, like the type you would do in the office, that's only going to be shared with other employees and attorneys in the office, right, is not going to be one-sided. Instead, if we want that full 360-degree view of everything that's happening in this case, we need to argue both sides. So in other words, we get to do our job for our client, but we also need to put ourselves in the shoes of our adversary, the attorney on that other side, and make their arguments for them so we can anticipate them, so we know what's coming, so we know what cases or what rules they might try to impress upon the court. So in other words, the legal memo is an internal document only shared within that law office. It's objective legal writing, meaning it's not one-sided. We're going to analyze and argue on behalf of both sides, our clients and the adversary's client. And what's it used for? What is it used for? It's used so that if we're in a law firm environment, I always make the comparison that me and all you students in my 3 sections of legal research and writing too, imagine us being a big law firm. That's a lot of attorneys, and that's not uncommon out in practice. So when that's the case, it's very common that a lawyer who's not necessarily handling a case on the day-to-day might need to go in for a court appearance, might need to argue a motion, might need to to conduct a deposition, might need to pinch hit in a client meeting. So the memo, in other words, does what? The memo is an internal objective document that allows any attorney in the firm to pick it up, read it, and have a really good understanding of what the case is about, what matters in the case, what are the legal issues, what are the arguments on both sides, and how are they likely to turn out in the long run. So as you can see, it provides a very important function to attorneys. I like making a lot of analogies and comparisons between what an attorney does as practicing law to what a doctor might do practicing medicine. Anyone who's gone to a doctor's office, basically at any time in their life, you know what? There's a file on you, right? It's protected by law, so it's between you and your physician. It's protected by a law called HIPAA, but there's a file on you, right, that has all your medical conditions. Why? Maybe at your doctor's office, there's multiple doctors. There's multiple doctors, and whatever doctor is coming in, they don't know that you might be allergic to this, or that you might have this pre-existing condition, or that you have this injury from a few years ago. They're not going to know that, so they skim the file, right? You change doctors. Same thing. You actually then have to sign what's called a HIPAA authorization, authorizing your old doctor to send that information to your new doctor. So then they could have the same benefit of all your medical history. Urgent care is becoming more and more prevalent in the medical and healthcare field. Same thing. When you go that first time, it's really annoying. You got to fill out all that paperwork as they're going through it, right? Before you can even see anybody. I know I hate it. I always when I call, if it's a place where you can make an appointment, I'm like, can I fill out the paperwork beforehand? One of the pieces of paperwork, though, is a HIPAA authorization so that they could get your medical history and medical file from your PCP, your primary care physician. So they need that to do their job. Lawyers need it the same way, right? Whether it's in the same firm, perhaps for some reason the client switches firms. Again, it allows the lawyer who has no familiarity with this case to go through and get a good idea of what's going on. So it needs to be done right, and it needs to be done well. And it needs to be done in a way that fits perhaps different styles and preferences of many different attorneys. So what I'm going to teach you today might be a little different than what Croft or Singh or Noe taught you. And what I'm going to teach you today might be a little different than what you'll do in law school. But what I'm going to teach you today, I find to be an adaptable foundation, regardless of what you've learned in the past, regardless of what you'll learn in the future, regardless of where you'll find yourself working now, during law school, or after law school. We're kind of going to put together this format that no matter what little curveballs or unique things that you might find yourself including in a memo down the road, or even currently if you're interning or working, this format fits. It's flexible. It allows things to be added. It allows things to be taken out if that's what the attorney wants. It allows you just a baseline for, okay, at its most simple form, this is what a memo should include and should look like, and I can adjust as needed. So that's sort of my philosophy, my approach in giving you a memo format. It's not the way I would want it if I was hiring one of you guys to work for me, but if I got it this way, I could make it work, and I could guide you on certain adjustments. So that's what I'm trying to let you leave with, the ability, the skill of putting together a again, effective, correct, and well done legal memo that any attorney at the end of the day could really understand and benefit from. So with that, let's break down the sections that go into a legal memo. So as you'll see on your screen right now, there's a strategy involved. It's not just about the sections. There's a strategy from my position on how you should approach them. So on the left, you see the 5 sections that should be, for full credit, included in your legal memo at the end of the semester, and should be, we'll talk about your next face-to-face, should be incorporated into your face-to-face from this module, Module 4. Those 5 sections are the heading, the facts, the issue or issues, if there's multiple issues, the discussion, and the conclusion or conclusions, as they're multiple issues, similar to what we have going on with our client, Mr. Hessler. So not only are those the 5 sections that should be included, that's also the order they should be in. And looking at this slide, I've actually done you a disservice, to be honest. I should have made it clearer when I sat down to make this slide. On the left here, right, I'm using my arrow, it should say these are the sections of the legal memo, and make this mental note or take this note down as you're sitting at home, and this is the order they should be in. This is also the order they should be in, right? I want to make this super clear. That's a bad slide. That's on me, not on you. But to not listen now and not take it down is on you. Those are the 5 sections that need to be included in this left-hand column. That is also in your memo, the order they should appear in. The order they should appear in. All right? I want to be crystal clear on that. And now seeing this, I'm going to really try to drive that home in your face-to-face. So in case someone goes back and watches this, they get it. Those 5 sections should be included, and they should be included in this order. Right? Now, just because that's the order they should show up when someone's reading your memo does not mean that's the order you should write them in. Instead, here's my recommendation. You should write them in this order here. And you're really going to see why, because we're going to discuss each one of these sections. Some don't require much talk at all, but I want you to have a good idea of what they are. And others, like the discussion and the issue conclusions, in fact, they will require a bit more. But when you write them, you're going to see why in just a couple minutes. I would approach writing them, strategy again, being efficient, doing the job correctly, quickly, and well. I would write them in this order, right? So let's start taking a look at all these different sections and what they are, right? Heading, simplest thing ever. This is basic information. Basic information. Who's the, right? We've all seen this. Emails have this. Who's the memo going to? Who's it from? What's the date? And what is it regarding, right? What's it regarding? Very easy. It's regarding the client. So this shouldn't take a lot of thought or a lot of concentration or a lot of effort. To put together a correct heading is probably about the easiest thing you will do on your memo. We'll do it together when I start typing up the memo for Hessler, but at the end of the day, there's no sense in not doing it first. It's an easy thing to just do and get out of the way. What happens later will in no way, shape, or form affect the heading. It's just basic information so that the person who gets it knows what it is when they start reading it. Pretty straightforward, pretty simple, right? Then we get to the discussion. And the discussion is the main event. This is the main course of your legal memo. This is the part that's going to set the tone for everything else you're going to write in the memo. When people read a memo, the discussion is sort of what they're in it for. I can't stress the importance enough of how it's done. Now, real quickly, you've probably at this point, given the fact that this is legal research and writing 2, it's not intro, it's not legal research and writing 1, you've probably done some degree of legal writing at this point, right? And looking at the left, that is most likely the format you've used. The format that's common to legal writing and is appropriate in some instances, but I'm going to tell you, I don't think it's the best for the memo, is what we call IRAC. And I broke IRAC down for you. IRAC stands for issue, rule, analysis, argument, or application. You will hear those terms used interchangeably by different professors. You will hear those terms used interchangeably by different practitioners, different practicing attorneys. They all mean the same thing in the terms of IRAC. Analysis, argument, application. It's all the same thing. You can use either one of those terms. And at the end of the day, conclusion, right? You make a conclusion. Now, for writing a good legal memo, I don't like writing in IRAC because to me, it gets redundant. What do I mean by that? So if we go back real quick to the sections of a memo, you see there's a section for issues. There's a section for conclusions. So if I'm creating a whole distinct separate section for my issues and a whole distinct separate section for my conclusions, it sort of makes very little sense to then include those again in your discussion. If I want the issue, I will look at the issue in a good written memo. If I want the conclusion, I will look at the conclusion in a good written memo. I don't need to see it over and over and over and over and over again. You gave it to me. I don't want to waste my time with that. So instead, what I recommend doing, and what we're going to do for this class, right, is instead of using IRAC, we're going to use what I call RAP. We're going to use what I call RAP. And this will make more sense on the next slide and as I'm writing it. But what a good memo will include for each issue is the rules, the arguments. I like to think of it as arguments. You can use the term analysis or application. Feel free. I prefer the term arguments. I think it's the best descriptor of what we're actually trying to accomplish. And then at the end, it doesn't end with a conclusion. It ends with a prediction. So instead of doing IRAC, we're going to use the RAP system, where we start with our rules, then we transition to our arguments, and at the very end, because that's what we're really trying to get out of a memo, is that prediction of if this case comes before the court and we're arguing about this issue, how is the court likely to rule? We want to have that prediction. So let's talk about it now. Right? How does this all play out? The rules, the argument, prediction, this RAP format. So for starters, every legal issue is best discussed, in my opinion, in 2 paragraphs. I don't need War and Peace. I don't need a novel. Legal writing is quick. Legal writing is to the point. Legal writing does not waste time or go off on tangents. Legal writing tells that attorney what he, she, or they need to know, tells it to them quickly, and it tells it to them in a way where they know what they're looking for so they can jump through and skim through, right? So each issue is discussed in 2 paragraphs. So if there's 2 legal issues going into your memo, that means your discussion should be 4 paragraphs. If there's 3 legal issues going on in a case that are ending up in a memo, that would be 6 paragraphs. If there are, do the math with me, people get this wrong every semester and it drives me nuts. I'm telling you the answer right now. Please, please, please. Let's all get it right. If there are 4 legal issues being analyzed and discussed in the memo, how many paragraphs? 8. 2 paragraphs per issue. With Mr. Hessler, we have how many issues? 4. Each one is 2 paragraphs. That's 8. I can't. It drives me nuts. It drives me nuts. It drives me nuts when I have students and I get their memo and I actually say, this is how many paragraphs your discussion should be. And it's not. And I'm like, oh God, I'm giving you the answer. 8 paragraphs. Your final memo at the end of the semester, 8 paragraphs. Today, I am doing, thank you, Olivia's got it. Olivia says 8. I am doing 2 issues for you guys today to demonstrate. That'll be 4. You all, right, are going to do in your face-to-face 1 issue as a team. That will be 2 for your discussion. It's simple math. Please don't mess it up, okay? But let's talk about what goes into each of those paragraphs now, because it's very, very different in each paragraph. So on the left, you'll see what I'm calling the rules paragraph. And remember, I'm going to demonstrate all of this. You're seeing what's called a rules paragraph. And I've kind of given you a little checklist of what goes in to the rules paragraph versus what goes into that second paragraph, which I'm calling argument and prediction paragraph. So the R in RAP gets its own whole paragraph. The A and P share one. A and P, argument and prediction, share one. What goes into the rules paragraph? This is where you're going to include, if there's a statute and it says something, I would hope it says something, otherwise why would we have it? But that goes into the rules paragraph. Case law rules. We've been working, right, really hard on reading cases and then sort of distilling them down into a 1-sentence case law rule. This is where this is going to come into play. You've done a lot of this work already. Keep telling you that. Here's where you're going to see it in action. Case law rules are going to go in your rules paragraph as well, right? Citations. We're going to talk about Blue Book citations, Module 6 in your rules paragraph. That's where the citations for these case law rules and for these statutes will wind up. They will all be in that first rules paragraph. And last but not least, from a writing perspective, we sort of with Module 3 face-to-face and these cases about party hosts and serving alcohol, we wanted to put them in a logical order. And a really good way to approach your legal writing in a logical order, now that we're focusing on the legal writing specifically, is to start very general and then get a little more specific as we go. So it's nice to start general and then get more specific. And every team sort of came to that conclusion in their Module 3 face-to-face. Pretty sure every team started with what? They started with that definition of the word procure. That was a really great place to start. And that sort of spoke to the statute. It spoke to the statute, okay? So that's what we want to do. We want to start if there's a statute or a general governing law, piece of case law, a very broad idea that applies, but we need to fill in the specifics. We start with that really broad idea, and then we build it down with our individual case law rules that apply that rule to certain sets of facts. You're going to see, again, when I demonstrate how to write one, how it works, but always think, I want to start broad. And then I'm going to get more specific with facts that are more similar to the specific facts of my case as I go on and on and on. So that is our first paragraph, our rules paragraph. Then we get on to the second paragraph for an issue. And we call that the argument and prediction paragraph, as I've said. And what are the differences? This does not include statutes and case law rules. So your statutes and your case law rules are in the rules paragraph. They do not belong in the argument and prediction paragraph. Similarly, they don't include citations. Your citations are in your first paragraph, your rules paragraph. They don't belong in the second paragraph for a legal issue. Number 3, like we talked about, objective legal writing, where we're analyzing the case from a 360-degree perspective. We need to make the arguments for both sides. How do we do that? Well, frankly, it's something you've been engaging in during your face-to-faces. You're going to compare facts and outcomes of the cases that you already gave me the rules for, and you're going to compare them to the facts of our case, right? So at the end of the Module 3 face-to-face, what did I do? I said, let's apply these cases. And y'all did. Y'all did, right? Are they harmful? Are they helpful? Why? And we saw that we could compare the facts of those cases plus their outcome, and we can either say it's the same in our case or, right, maybe it was different. The one example I'm thinking of is that D'Amico case, D'Amico v. Christie. What went on there? They had that employee association picnic where the guests brought their own alcohol. It was the BYOB, and that was kind of why the court decided that that employees association was not liable for the injuries that happened to D'Amico, right? But that didn't mean it was bad for us. It was good for us. Why? Because our case was different. Our case was different. Our case was not BYOB. It was Novik's party host providing the alcohol to Miss Novik and to all the other guests. Wasn't BYOB. So the outcome should be different because the facts are different. That's the argument. Or let's talk about the Holiday v. Poffenbarger case for a second. Holiday v. Poffenbarger, that's the one where the college student goes to a frat party, gets kicked out, and then gets drunk and gets kicked out, gets more drunk. He had started drinking beforehand, gets kicked out, and then goes across the street and stabs somebody. And the guy who got stabbed is trying to sue the fraternity, saying, hey, you overserved this guy. And what does the court say there? The court says, no, they're not liable. They're not liable because, right, this was happened after he left their property. They served alcohol, sure, but once he leaves their property, they're good. And that case, on the other hand, is very similar to our case. And from Mr. Hessler's perspective, that's a tough argument to make. For Miss Novik's party host, that's a really, really strong argument to make, applying the Holiday v. Poffenbarger case. But I think you're getting the point. This is something we've been doing. We're just now going to put it into writing, making the arguments for both sides, and at the end, weighing them and coming to that prediction. Okay? And at the end of the day, we must conclude the argument and prediction paragraph with a prediction. A prediction's very, very straightforward, very simple. It's nothing fancy. We shouldn't have a great deal of trouble mastering it. Again, you'll see it as I demonstrate it to the class in the second part of today's live stream, right? So we can't forget it. There's a tendency every semester. It's an argument and prediction paragraph, which means what? It means we must conclude with that prediction. Don't leave it off. It is every bit as important as the rules, and it's every little bit as important as the argument. It seems silly. It seems insignificant. It might even seem obvious if you're just reading the arguments. We need to conclude with that prediction. It is a key part of the memo so that an attorney can see, right, how a legal issue is likely to be decided. Right? Moving right along, let's talk about the legal issues, right? So we know, I'll start at the bottom actually, we know it's framed as a question. We kind of got that sense by now in doing some case briefing. It starts with the word whether. That's always a really good place to start, and ends with a question mark, right? But here's the thing with an issue statement. It needs to be, and this sounds like an oxymoron, but I'm going to explain it to you. It needs to be both general and specific at the very same time. So what do I mean? When I say it needs to be general, I don't want to know Hessler's name. I don't want to know Novik's name. I don't need to know these things. We need to characterize plaintiff, social host, individual, defendant, supermarket, school, whatever the case may be. In other words, we're not going to get caught up on, when we're writing our issue statement, on Mr. Hessler and Miss Novik. Why? Because the court's not looking to make a rule for Mr. Hessler and Mr. Hessler only. Court's looking to make a rule for any plaintiff in this position. Court could care less that this guy's name is Edwin Hessler. And at the end of the day, that's how the cases read. That's how legal rules are construed. If they were to make a rule that applied to Mr. Hessler is contributorily negligent when, well, that rule, think about it. If that's what the case said, then that rule applies to only who? Only Mr. Hessler. So the court ain't trying to do that. So when we frame an issue and then we have our conclusions, right, we omit all that proper personal identifying information and characterize the parties and the players in a way that's broad enough that it can encompass two different people that come up with this same situation down the road. But at the same time, we're also specific. What do I mean by that? Well, we got to include the facts that matter, right? We need to include the facts that matter. And this is, again, something you guys got some practice in through the first 3 modules. We can't just say in our issue, whether the issue is whether Hessler engaged in serious illegal conduct. That tells the reader nothing. A better issue is whether Hessler engaged in serious illegal conduct by looking down at his cell phone to make a call while driving. You see that difference there? So that if someone's reading this, it actually tells them what's going on. Because the issue is not, in a very, very, very broad sense, whether Hessler engaged in serious illegal conduct. Great. But if I'm the attorney reading that, I'm like, what do you do? I got to go to some other section to figure it out? Put it in there. I'm going to put that in our issue. Whether Hessler engaged in serious illegal conduct when he looked down at his cell phone to make a phone call while driving. That's the type of specificity we're looking for. So it wouldn't include Hessler's name or Novik's name, but it would include, the specific factual scenario. Question from Olivia. So instead of their names, we say like defendant, so it's applicable to anyone? Yes, while still being specific to the case, yes. So in other words, we're not going to be specific with the parties. We're going to be general in our characterization of the parties, plaintiff, defendant, social host. But when it comes to the facts, we're going to say exactly what they did. We're going to say exactly what they did. I hope that answers Olivia's question. Moving right along, okay, from our issue, we're going to go, good, she got it. All right, we're going to go on to the conclusions. Now, the conclusions, again, this shouldn't be foreign to us, right? The conclusion is a lot like a rule coming out of a case. In fact, what we're doing with a memo is we're kind of synthesizing a bunch of cases together, a bunch of rules together to create a rule that sort of combines all of them, okay? And it's literally a mirror image of the issue. So your conclusion and issue should read the same way. The only difference is that a conclusion is a definitive statement. It's not a question. So we wouldn't start with whether. We would just start with whatever is behind whether, for lack of a better way of describing it. And it's going to end with a period instead of a question mark. We're just going to take that question that we posed in the issue, and we're going to take that same exact sentence structure, and we're going to turn it in from a question to a definitive answer. So-and-so is liable when. So-and-so does have a duty to. We take that question, we make it into a definitive sentence, an answer, and that's all it is. They should be the same with very small minor differences. So I've had students in the past, they write beautiful issues, and then for a conclusion, they go on like it's a philosophy course. It's not. It's one sentence. It's just taking the issue, turning it into an affirmative statement, either for the positive or for the negative, whatever the case may be. You shouldn't be spinning your wheels over making a conclusion. Olivia gives it a great example. Issue, whether the sky is blue. Conclusion, the sky is blue. Yes, I couldn't think of a better way to say it than that. Thank you, Liv. Okay? And last but not least, we have the final section, and this will be, interestingly, one of the first sections when you're reading the memo, but it's one of the last ones you're going to do. Why? Because you need your discussion and you need your issues to tell you what belongs in here. So when you think of like facts, I say it right there. This isn't a thesis that explains every single thing about a case. Okay? You could probably, if you wanted, based on everything we know about Hessler's case, write like a couple pages if you really want to go into his injuries and his lost work and the money he lost and the pain he feels and it happened on Hamilton Avenue and all this. You don't need it. All you need are the facts that are relevant, the facts that, in other words, play a role in your discussion. If they play a role in your discussion, they're going to be mentioned in your issue and your conclusion. And those are the facts that get put into your facts section. I don't need a treatise or a textbook on Mr. Hessler. It's not what I'm looking for. It's only those facts that matter. In fact, right, you can almost put them in bullet points. You're not going to. It's going to be a paragraph. It's a narrative form, but that's kind of how I want you to think of it. You're not going to write them in bullet points, but I want you to think of it that way. A few quick bullet points about what mattered, right? What do we know that mattered? All right, today we're going to be talking about our contributory negligence arguments. Those are the two I'm going to do. We're going to look at serious illegal conduct, and that's going to be included in the memo I'm going to write today. And then we're going to look at the percentages of fault. And that's going to be included in today's memo as well. So what matters? What are we concerned with? Hessler's behavior. What did Hessler do? Hessler looked down at his phone while driving to make a call before the collision. That's what matters. That's all that matters for these two issues, isn't it? Right? I might want to put a little sentence in that at least just gives a little context. He got into a collision with Miss Novick. But for the issue that I'm writing the memo on today, the two issues actually, the facts are just Hessler's behavior. What was Hessler's behavior? Look down at his cell phone and make a call while driving immediately before the accident. That's it. So you'd probably think, oh, I got to go on and tell the whole Hessler-Novick story. No, you don't. You just got to give the facts that matter, right? And the litmus test, meaning like the filter, the judge of whether it should be included or not, if it's not included in your discussion, and if it's included in your discussion, it should work its way into your issue and conclusions. It shouldn't be included in the facts. It's that simple. If you're not talking about it in your discussion, then it shouldn't be in your issue and your conclusion, and then it really shouldn't be in the factual section. Why? It's not relevant to the issues we're analyzing, the issues we're writing a memo on. It's not pertinent to the outcome of the case should the court decide those legal issues, right? In other words, if it ain't in those things, it doesn't matter. It don't matter, right? There might be cases that are more complicated. I don't want y'all to get the wrong impression. This is a very simple case. It's intentionally simple because y'all are learning. There's cases where a lot of different things matter. The damages and the injuries matter. The time, the street conditions matter. There could be all kinds of factors that do matter, but that's at a more advanced level. Let's learn to walk before we learn to run. And that's my goal. I don't want to overcomplicate this for you. I want to make it simple, but sometimes simple's the best way to prevent y'all from overthinking it. I know when I was in your position, I would overthink everything, learning how to apply a law and read law and construct rules, and it's more straightforward than you think it is. So when you kind of break it down to that level of if it's not in your discussion, it doesn't belong in your facts, I really couldn't think of a clearer way to illustrate that point. Okay, so that is what a memo is. That is the sections of a memo, the order they should be in, and then the sections of a memo and the order you should approach them in, and kind of an idea of what your average attorney is looking for out of each section going forward. All right.